I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. A federal judge in the Washington, D.C. federal courthouse who's overseeing the secret grand jury proceedings relating to election interference in the 2020 election. This judge just made a monumental ruling, and the ruling was to grant the Department of Justice's motion to compel testimony over Donald Trump's objections for executive privilege. This specific motion that was filed by the Department of Justice related to former Vice President Pence's former Chief of Staff, Marc Short. Trump was trying to block Marc Short's complete testimony before the criminal grand jury in Washington, D.C., and the federal judge, Chief U.S. District Judge Beryl A. Howell, denied Donald Trump's assertion of executive privilege, granted the Department of Justice's motion to compel. And so this was the reason that before the January 6th committee hearings took place on Thursday, observers saw Marc Short leaving the federal courthouse in Washington, D.C. with his lawyer, Emmett Flood. And we'll pull up that video right now of him leaving the federal courthouse with Emmett Flood. People were trying to guess, why was Marc Short, Vice President Pence's former Chief of Staff, former Vice President Pence's former Chief of Staff, why was he leaving the D.C. courthouse? Well, now we know he was giving complete and full testimony and was not permitted to assert the executive privilege. So let's rewind a little bit to give you the timeline here. So Mark Flood, who was the former Chief of Staff to former Vice President Pence, originally gave grand jury testimony back in July. You may recall reports of Marc Short giving this testimony, as well as Greg Jacob. Greg Jacob was the top lawyer to former Vice President Pence at that time, and they both were giving testimony before the grand jury. What we're now learning is at the time they were still asserting an executive privilege objection because Donald Trump had asserted executive privilege. So Marc Short and Greg Jacob at that time said we could testify about everything but just certain communications with Trump or observations related to Trump, other types of knowledge that we may have learned about Trump we can't talk about. We can maybe give you general observations or things that don't relate directly to what Trump said to us or what we observed, because Trump is claiming executive privilege, and that issue needs to be resolved with the court. So then you may recall, around September 22nd, you had a number of Trump lawyers were seen leaving a federal courthouse at that time. And we had seen in September 22nd, it was Evan Corcoran and a number of other lawyers leaving. And we're like, why are Trump's lawyers in the federal courthouse in D.C. on September 22nd? Well, they were there because oral argument was being held before this district court judge over the issue of executive privilege, with Donald Trump trying to block Marc Short's testimony asserting executive privilege. What we've also now learned, though, is the federal district court judge, Beryl A. Howell, she denied Donald Trump's assertion of executive privilege, ordered that Marc Short would have to testify fully, and he cannot assert executive privilege, so provide all of the information, not just kind of selective pieces of the information. Donald Trump tried to appeal that to the D.C. Circuit Court of Appeal, the appeal court over seeing the district court's decisions. And the D.C. Circuit did not grant Trump's efforts to stop Marc Short or to stay or prevent Marc Short from testifying pending Trump's overall appeal. So Marc Short had to testify and could not assert the executive privilege. And indeed, Marc Short, again, former Vice President Pence's former Chief of Staff, testified fully on Thursday, October 13th, regarding all of his knowledge, all of his observations regarding January 6th, leading up to January 6th, after January 6th. And you'll recall, you've seen Marc Short on the video depositions that were played at the January 6th committee hearing. Marc Short was very critical of Trump, very critical of his actions. You saw Greg Jacob, who was very critical of Trump's actions, and Greg Jacob gave live testimony. But there were some areas where they could not discuss, where they asserted executive privilege. And similarly, you may recall from the January 6th committee hearing testimony, people like Trump's top lawyer, White House lawyer, Pat Cipollone, and Pat Cipolloni's top deputy, Patrick Philbin, who gave testimony to the January 6th committee. But when they were asked questions about Trump, they had to assert, or they were told that they had to assert the executive privilege or claimed the executive privilege before the January 6th committee. Well, what this judicial order by Chief U.S. District Judge Beryl A. Howell in these grand jury proceedings establishes is not just related to Marc Short, and Marc Short had to testify. It's not just related there because the implications is that Donald Trump may not be able to and likely won't be able to assert executive privilege to block all the other individuals from providing testimony to the grand jury in connection with the Department of Justice's ongoing criminal investigation into 2020 election interference. And you'll recall, for example, back in September, in addition to their testimony before the January 6th committee, which is providing and performing an investigative function, you have Pat Cipollone and Patrick Philbin, the top deputy to Pat Cipollone, the top White House lawyer to Donald Trump. They testified before the grand jury, the criminal grand jury that's impaneled in Washington, D.C. as well, before U.S. District Judge Beryl A. Howell. And so it's possible that during that testimony, they had to assert the executive privilege based on Trump making this claim of executive privilege. Trump claimed to be the holder of the executive privilege and said, I'm not letting Cipollone and I'm not letting Philbin testify the same way he said, I'm going to prevent or assert executive privilege to block Short from testifying on certain topics. Well, the ruling as it relates to Short will likely apply to Philbin. It will likely apply to Cipollone. It'll likely apply, frankly, to anyone else who goes before the January 6th investigative grand jury, criminal grand jury that the Department of Justice has impaneled. And so remember, there's two things going on. There's the work of the January 6th committee, which is a congressional committee. They don't have criminal indictment powers. They can make criminal referrals, but they do an investigation and prepare a report. That's just the limitations of what congressional committees can do. Separately, there is an ongoing criminal investigation, multiple, that the DOJ is leading. The DOJ impanels a grand jury, a criminal grand jury, and the DOJ presents evidence to the grand jury. The DOJ is able to utilize the grand jury procedures to issue subpoenas for people to have to show up and give testimony and provide documents and to provide records. Now, normally, grand jury proceedings are confidential. They're done in secret. That's the way grand juries are supposed to work. So you may see a case in re grand jury, but the entire docket is completely sealed. And the idea of why you seal a grand jury docket before there's a prosecution is because all grand juries don't always result in criminal prosecutions. Also, the Department of Justice, the criminal investigative body, also doesn't want to reveal its secrets about how it's conducting its operations. And so its criminal investigative procedures, they want to keep that confidential as well. And so grand jury procedures pre-indictment almost always are kept secret. I mean, the one rare exception is where you have a situation where Trump filed that weird motion arising out of the search warrant executed at Mar-a-Lago. He filed that motion for judicial oversight before Judge Eileen Cannon, and necessarily things became public, by the way, which were very incriminating for Donald Trump. But the purpose of the grand jury secrecy is also, though, to, if people are presumed innocent until found guilty, the idea also is to keep that process and procedure, behind closed doors, in addition to the reasons why I mentioned, to keep the investigative tactics secret as well, but here there was obviously a leak. I mean, that's how this is known. The very fact that we know that the Chief U.S. District Judge Beryl A. Howell made this ruling granting the Department of Justice motion to compel and rejecting Donald Trump's executive privilege claim, somebody leaked that information. That's not coming from a publicly filed docket. So who was it that leaked it? There's a number of suspicions of who it could be, but a message is clearly sent now to other people who will be testifying that you cannot assert executive privilege and that Donald Trump's claim of executive privilege here has been denied. There's likely a lot of reasons why the executive privilege claim would be denied. First off, as the Hornbook law, one of the things that we've talked about, 101, is that executive privilege cannot be asserted, or usually in most circumstances cannot be asserted by the previous administration. Former presidents don't have executive privilege. Executive privilege lies with the current executive branch. Only the current executive branch can invoke it, and here they're not invoking it. Two, there's crime fraud exceptions. You can't use executive privilege to try to shield criminal conduct and unlawful and illegal conduct. Third, there shouldn't be executive privilege because Trump talks about lots of these things publicly. I mean, he wrote a letter today to the January 6th committee, basically, again, spreading election disinformation, further spreading information that, just crimes, just lying and spreading fraud in this letter. But he's talking about these things publicly there at these rallies. And so you can't assert an executive privilege and then talk about the things publicly because executive privilege is intended to cloak or keep secret confidential communications in a deliberative sense between the President of the United States and others, and it's intended not to chill the free flow of information that the president is getting while they're serving as president. That's the concept behind an executive privilege, why a president should be able to, in normal circumstances, assert a privilege claim, because otherwise what they would be afraid of is that there would just be a constant barrage of subpoenas and information to try to gain their secrets, and we normally would want to protect the secrets of presidents who don't try to overthrow our democracy. So that's the basis of it. But this, again, is a huge, huge, huge ruling with far-flung implications that I can't just stress enough, that we now have in these grand jury proceedings that are taking place, these criminal grand jury proceedings taking place. We now are aware that executive privilege cannot be asserted there, that Trump's ability to attempt to try to block testimony on the grounds of executive privilege was rejected, that you have people like Marc Short now testifying about things the January 6th committee didn't even have access to, because the January 6th committee, you remember with the Pat Cipollone deposition before it, he said, I can't answer those questions, executive privilege. And the January 6th committee, because they wanted his testimony, they didn't fight it or contest it because of the time sensitivity around their mandate. Whereas the Department of Justice, through the special grand jury process, which is the secret criminal grand jury proceedings, they fought it out with the judge, and a federal judge allowed them to ask these questions, get answered, and the judge is not letting Marc Short and likely any of the other individuals who met with Trump or spoke with Trump from asserting executive privilege. One of the things we also know, and it's worth mentioning as well, who was also seen at the federal courthouse on Thursday, none other than Kash Patel, who is believed to also have been speaking with the criminal grand jury impaneled by the Department of Justice investigating Donald Trump's criminal conduct in connection with 2020 election interference. Again, now Kash Patel likely also wouldn't be able to assert executive privilege on for the same legal reasoning. I'm Ben Meiselas from the MeidasTouch podcast. Hey, hit the subscribe button right now. We are on our way to 1 million subscribers, thanks to you. Also, if you want to join us on Patreon, help grow our independent media network. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.